Hi everyone, this is Veronica, and today we are going to discuss the topic that is euthanasia and living will. So, this topic is available in both Hindi and English languages. This lecture is in English, but Hindi lecture is also available. You can surf on YouTube under StudyIQ. If you have any queries, you can mail me, and for my video updates, you can follow me on Instagram and Facebook. So, in my Hindi lecture, in one of the comment, I found that somebody has pointed out at the pronunciation of the word. So, whether you pronounce it as euthanasia or euthanasia, both are correct according to Britain and American pronunciation. So, whatever you feel comfortable, you can pronounce as such. So, let's move forward. This is a channel Study IQ, and if you're preparing for any government exam like SSC, bank, or UPSC, you can buy our pen drive and tablet courses. Even our UPSC test series is also available in both English and Hindi. And for that, to confirm for the orders, you can call on these numbers or you may log in into our website. So, what all we are going to discuss today are like what is the issue? What is the issue regarding euthanasia, living will, types of euthanasia, what is the case, what are the complications of living will. So, the terms will be discussed in this lecture. The bill, which is yet to be introduced in the parliament, the treatment of terminally ill patients bill, is also ready. And what is the way forward regarding euthanasia and living will? We'll discuss all that. So, now what is the issue? The Supreme Court, in landmark verdict in 2011, ruled out active euthanasia and laid down a legal framework for passive euthanasia. Now, what is the difference between the two? We will discuss in our subsequent slides. Now, this 2011 case is basically Aruna Shanbag case. Now, this lady, unaware of her unwanted fame, the 67-year-old became India's metaphor for the right to life. The Supreme Court, in this case, Aruna Shanbag case, allowed passive mercy killing, that is, passive euthanasia of a patient in a permanent vegetative state by withdrawing the life support system with the approval of a medical board and on the directions of High Court concerned. Now, what is vegetative state? A vegetative state is a condition in which someone is awake but not aware. People usually emerge from a coma into a vegetative state as their brains slowly recover from injury and they start to become more alert and aware. From a vegetative state, a patient can move into a minimally conscious state, then into a state of full consciousness. However, sometimes patients do not recover from a vegetative state because their brains are too badly damaged, like in the case of Aruna Schonberg. Now, recently there's an NGO named Common Cause who filed a petition on the issue of living will in relation with passive euthanasia, and on all the important matters central government also gave its stance, and in this case central government has taken a stance against the living will. Now, the Supreme Court, which earlier legalized passive euthanasia, has now come out strongly in the favor of living wills. The government, on the other hand, is hesitant to allow making living will on the ground of possibility of its misuse. Now, let's see what is the meaning of the words euthanasia. Now, it means intentionally ending a life in order to relieve pain and suffering. Now, euthanasia is deliberately bringing about a gentle and easy death, making the last days of patients as comfortable as possible. This is to ensure a calm and peaceful death within the context of relieving incurable suffering in terminal illness or disability. Now you can see that this word is derived from Greek word eu, which means goodly or well. Thanatos means death, and it means a good death. So this is about euthanasia. Now, what is living will? It is a written statement detailing a person's desire regarding future medical treatment. A living will is also known as advance directive. It is a legal document that specifies the type of medical care that an individual does or does not want in any event that he is unable to communicate his wishes, when he is not able to communicate his wishes. In the case of an unconscious person who suffers from a terminal illness or a life threatening injury, doctors and hospitals consult his living will to determine whether or not the patient wants life sustaining treatment such as assisted breathing, tube feeding, ventilator, or anything like that. Now, there are different types of euthanasia. We'll discuss them. Firstly, it is active euthanasia. Now, active euthanasia is taking specific steps to cause the patient's death, such as injecting the patient with poison. In practice, this is usually an overdose of painkillers or sleeping pills, something like that. Now, what is passive euthanasia? It is usually defined as withdrawing medical treatment with the deliberate intention of causing patient's death. For example, if a patient requires kidney dialysis to survive and the doctors disconnect the dialysis machine, the patient will die fairly soon. Perhaps the classic example of passive euthanasia is a do not resuscitate order. Normally, if patient has a heart attack or similar sudden interruption in life functions, medical staff will attempt to revive them. If they make no such effort but simply stand and watch as the patient dies, this is passive euthanasia. In other words, difference between active and passive is that in active euthanasia, something is done to end patient's life, and in passive euthanasia, something is not done. Okay, not done that would have preserved the patient's life. There are two other types of euthanasia also. One is voluntary euthanasia and other is involuntary euthanasia. Now, voluntary euthanasia is when the patient requests that action be taken to end his life or that life-saving treatment be stopped with full knowledge that this will lead to his death. And in involuntary euthanasia is when a patient's life is ended without the patient's knowledge and consent. This may mean that the patient is kicking and screaming and begging for life, but in practice, today it usually means that the patient is unconscious, unable to communicate, or is too sick and weak to be aware of what is happening or to take any action on his own behalf. So, these are the types of euthanasia. Now let's see what is the present case. Now, in this case, the center has informed that management of patients with terminal illness, withdrawal of medical support bill is ready. As I told you, in 2011 Aruna Shanbhag case, Supreme Court has said that until a law or act is ready regarding euthanasia, passive euthanasia, as it is already legalized in our country, passive euthanasia will take place in our country under the guidelines prescribed by Supreme Court. But now the government is ready with the bill. Now we'll see a little history that why euthanasia, talking about euthanasia today is important, because in past there were many cases people demanding euthanasia. Now I'll give you examples of such cases in the past. In 2008, there was a man named Jeet Narayan from Uttar Pradesh. He was the father of 4 sons from Mirzapur, UP, pleaded for euthanasia for all his sons. His sons were suffering from muscular dystrophy, that's a paralysis, neck down. The children cannot move or walk or even stand. They are completely dependent on their family for the most basic things like picking up a glass of water and eating, things we take for granted. So Jeet Narayan wrote to President Pratibha Patil at that time for the dignified way to end their suffering in 2008, only to get a rejection in couple of months. Then in 2010, there was a lady. She was penniless and abandoned by family. She was the first female euthanasia petitioner from Karnataka. The 74-year-old was so frustrated from living alone in an old age home and was in acute pain from over a decade from slip disc and other age related ailments in an old age home from over a decade, and she wanted to get euthanized. Then in 2013, Dennis Kumar from Tamil Nadu, this construction worker from Kanyakumari, was aware of the irony in his demand. Parents usually wish for a healthy life for their children. Yet, Dennis filed to euthanize his 11-month-old son, who was in vegetative state since birth. No doctor has even been able to diagnose the problem with the child. But yet, he was also not granted this euthanasia demand. And recently, there are some more cases also. There is a wife of a daily wager who is bedridden and is demanding euthanasia. So that's why now we are talking about euthanasia, and government is also ready with the bill. Now in this bill, the court has, as I already told you, now the court has indicated that it may let down comprehensive guidelines to operationalize living wills. However, I told you government is totally opposing the concept because they are afraid of the misuse of living will. Now let's see what are the complications if living will is legalized. Now see, we have Article 21 which gives us right to life, but under no condition it could be interpreted that it provides us right to die also. Now Article 21 provides that for the deprivation of life there should be a fair, just and reasonable law and a procedure established under it. By various verdicts, even Supreme Court has extended the definition of right to life as a right to dignified life, meaning right to dignified life, meaning not mere animal existence but something more. But if we legalize living will, that means it will contradict our legal stand that right to die is not there in the constitution, and if it is legalized, it will contradict our Article 21. So now there are even social and moral complications with living will, as most dangerous thing is the misuse of the provision, as the government is also afraid. But there are two good things also on moral grounds, as allowing it would relieve the close family members of terminally ill patient of moral burden of making life ending decisions, so they won't be guilty anymore. And next, a living will would also rule out the possibility of doubting the life terminating decision as murder. So, if somebody has already given a living will and a person on his behalf takes a decision or provides the doctor with his own living will of the patient, then that person won't be charged for murder or anything. So, it will purely on the consent of his, or will be based on the living will of a particular person. So now this is the bill which was proposed in 2016 regarding terminally ill patients bill. Here the medical practitioner is supposed to inform the patient of all the available treatment options. Next, the person who can demand for euthanasia should be between the age of 16 or more. And in the case of minors, maybe parents or guardians could be able to take the decision. Next, the direction issued in this regard will be binding on the doctor. And in this bill, living will is totally rejected. It is not taken into consideration. The bill declares advanced medical directives and medical power of attorney as void. Now, what does this mean? Let's see. Now, this means if there is a person, this is the person A and this is the person B. Now this person says, when I won't be in my conscience, then this person can take a decision on my behalf for my life. So this person A is shifting his power of attorney for his life to person B, but it will be considered as void and null in the case of passive euthanasia in our country. So here is the complication. Here is the here where the complications arises. So in such cases, a doctor, hospital, or a relative should have to approach a court to withhold treatment. The court will appoint a panel that would dispose of the matter in a month. Then, significantly, this delay in procedure is a cause of concern, as there are situations where survival would not be possible. It could be painful for the family and the patient to wait until a decision comes. Now, this was the case in Aruna Schonbach case also, where this Indian nurse who spent around 40 years in vegetative state as a result of sexual assault. Now, what happened in this case was that the bench said that they are laying down the law in this connection, which will continue to be the law until Parliament makes a law on the subject. So, in this Aruna Schonbach case, they said the parents were dead and other close relatives have not been interested in her ever since she had unfortunate assault on her. It is the KEM hospital staff who have been amazingly caring for her day and night for so many long years, who really are her next friends, and not Miss Pinky, actually, who filed the petition in the Supreme Court asking for euthanasia for this lady, who has only visited her on a few occasions and written a book on her. Hence, it is for the KM hospital staff to take the decision. The KM hospital staff have clearly expressed their wish that Aruna Schonbach should be allowed to live. That is why she was not granted euthanasia, but she died in 2015 due to pneumonia. Now, this is the new bill, which is slightly different and it is a welcome step. Now, it moves away from decision making based on the best interest of the patient and recognizes the right to die with dignity. But however, it does not permit euthanasia, active euthanasia. And once the practitioner or the doctor is satisfied with the patient is competent to take the decision, then it will be confirmed by the panel of 3 independent medical practitioners. This is given in the new bill. Now let's see what is the status of euthanasia in other countries. Like in April 2002, the Netherlands became the first country to legalize euthanasia and assisted suicide. Now, what is assisted suicide? In assisted suicide, a doctor provides a patient with the means to end his own life, but the doctor does not administer it. For example, if a doctor gives you an injection of morphine sufficient to cause your death, this is euthanasia. But if the doctor puts the hypodermic needle besides your bed, explains to you what it is, and leaves, and you later inject yourself, this is considered assisted suicide. So, in Netherlands, it is imposed a strict set of conditions. The patient must be suffering unbearable pain, their illness must be incurable, and the demand must be made in full consciousness by the patient. In USA, doctors are allowed to prescribe lethal doses of medicines to terminally ill patients in 5 states of US. So, as of October 2015, human euthanasia is legal in Holland, Belgium, 5 states of USA, Ireland, Colombia, Luxembourg. Okay, so this is about the status of euthanasia in different countries. Now, this could even come as an essay in your mains examination of euthanasia. So, we'll discuss both the points which are in the favor of euthanasia and against euthanasia, and you can conclude accordingly. So, we will discuss both the sides. So, first we'll take up in favor of euthanasia. Now, say in a country like India, where hospitals are overcrowded and we face shortage of beds and have too many patients, some argue that they should let those die that do not have chance of living on. In that way, there could be more room for patients with diseases that can be cured. Other point is, it provides a way to relieve extreme pain. It provides a way of relief when a person's quality of life is low. Then there are some legal points, like in a democracy, a person has the right to decide whether he or she wishes to with his life or her life, a person who is suffering has the right to choose what should be done with his or her life. So these are the points in favor of euthanasia. Other point could be euthanasia has far-reaching financial implications. There are many people in India who are in vegetative state. Even if we spent any amount on them, they would never recover. One would simply prolong the life of suffering and pain while spending a lot of money. So, in these cases also, they said euthanasia should be allowed for peaceful death and it should be medically monitored. Other point you can add is like euthanasia can save life of many other people also. How? For example, when people become old and especially when they suffer from terminal illness or incurable diseases, they still have vital organs which could be donated to other people, and this can pave the way for much better world. So these are the points in favor of euthanasia. Like other point is it could be regulated as they are being regulated in other countries where it is legal, and euthanasia happens anyway. That means death will come anyway. Now we'll discuss the points which are against euthanasia. Those who say that euthanasia is morally incorrect. It should be forbidden by law. It is a homicide and murdering another human cannot be rationalized under any circumstances. So euthanasia can be misused is the biggest fear. Many psychiatrists are of the opinion that a terminally ill person or someone who is old and suffering from an incurable disease is often not in the right frame of mind to take a call. Such a person deciding to die may not be a rational call. Even the family members deciding on the behalf of the patient can also lead to abuse of the law, legalizing euthanasia. Even on a religion view, many religions think that euthanasia is immoral. Next point could be there is always a chance of medical miracle. As we are talking about terminally ill people, then which set of people could be considered as terminally ill, because miracles do happen in medical science. Next could be mercy killing would lead to a slippery slope effect, which is when those who are unable to voice their desires are put to death, like the senile or a baby or someone in a coma and so on. It would cause decline in healthcare and cause victimization of the most vulnerable sections of the society. So these points are written also, some of the points. So you can even add more points in the comment box and let me know what do you guys think. And please try to write an answer. Here I have given the questions. Discuss the euthanasia with respect to Article 21 of our Constitution. We have discussed that. What are the salient features of the treatment of terminally ill patients bill? So whatever is your stance, whether against or in favor, conclude in a nice manner. Like how will I conclude it? If I have to write an answer, I may conclude it like the most common argument against hastening the end of a life patient's suffering is that no one can be denied the right to life. However, life is not only a heart pumping blood into vessels. Life is not merely a pair of lungs lying behind a heaving chest. Life is not various other organs being whipped to work with advanced machines. Life is not just greenish undulating patterns on the screen of a monitor. Life and life support system is merely existence, devoid of even basic dignity, which is the natural right of every human being. Can we call mere existence without any awareness of it life? Is prolonging the sufferings of such victims of fate not a disservice to them? Therefore, if a patient is in extremely vegetative state where there are no chances of revival, a permission for mercy killing should be granted to him. However, in order to ensure that this law is not misused, the person's medical conditions should be checked by 4 or 5 different boards of doctor, so that it is absolutely confirmed that under no circumstances the patient condition should be brought back to normalcy. So this is how you conclude in a positive way. So I would like to see your answers in the comment box if possible. Thank you so much. And queries could be handled. I can handle the queries on my email, Instagram, or Facebook, wherever you feel comfortable. Thank you.